Hello everybody. My name is Chris Galvin. I'm with the International Code of Conduct Association here in Geneva. Thanks for joining us for today's webinar on human rights, private security and the law, where we'll be considering whether a number of legal developments are putting us on an evolving path to effective accountability. I'm delighted to introduce our panelists today, all outstanding human rights lawyers who will be sharing their perspectives on a number of emerging trends. Before I introduce them, just one quick word. We welcome questions throughout this webinar. We can't see you, we can't hear you, but you can submit questions. I would ask you to do that using the Q&A, please, rather than the chat. That makes my life easier. So to our panelists, first I'd like to introduce Adam Smith-Anthony, who's head of the business and human rights practice at Omnia Strategy. He's a qualified solicitor advocate specializing in public, international and human rights law. Adam advises and represents businesses on matters of corporate responsibility and business and human rights. We have Jonathan Drimmer, who is a partner in the litigation department at Paul Hastings Law Firm in Washington, DC. He's a recognized international expert on anti-corruption and business and human rights. Before joining Paul Hastings, he was Deputy General Counsel and Chief Compliance Officer at Barrick Gold, one of the world's largest mining companies. And finally, we have Mary Johnson, who's an international lawyer and founder of Fair Play Human Rights Consulting, advising companies on human rights issues arising in their business and supply chains. Mary's worked with Fortune Global 500 multinationals and small and medium-sized enterprises to implement good policies and practices, and she trains businesses on the UK Modern Slavery Act, and which is to Mary who we first turn. Mary, if we can start with you and look at the issue of modern slavery. The code itself requires that companies will not use slavery, forced or compulsory labor, or be complicit in any other entity's use of such labor. So can you please tell us what legal trends are emerging on this issue, and perhaps really start by explaining what exactly do we mean by the term modern slavery?
Thanks a lot, Chris, for that great introduction, and thanks also for inviting me to join in the webinar today. I'm really looking forward to our discussion. So speaking of modern slavery, I think you're quite right. It's important that we start by defining terms. I know that's very lawyerly of me to say, forgive me. So what exactly are we talking about when we're talking about modern slavery? It's really an umbrella term that is used to describe lots of different offenses, including human trafficking, slavery itself, forced labor, domestic servitude, and then slavery-like practices, including debt bondage, the sale or exploitation of children, and also forced or servile marriage. So all of these different actions are quite varied in nature, but the thread that runs through all of these actions and why we put them under the umbrella of modern slavery is that it all involves one person depriving another person of their liberty in order to exploit them for either personal or commercial gain. So modern slavery, it's important to remember, is not an isolated phenomenon, but it rather sits on a spectrum of labor exploitation and abuse. So it can, indicators can include things like wage theft or excessive working hours, which in themselves might not classify as modern slavery, but can quickly deteriorate into those slavery-like practices by the use of threats and coercion. It's important to note, I think, that this isn't something historical that we're talking about. It's actually the fastest growing criminal industry in the world. It's the second most profitable criminal industry, second only to drugs. And this growth is being driven by international gangs who recognize that there's a lot of money to be made from controlling people in workplaces. And the thing that I always like to drive home when I do training for businesses on modern slavery is that we have to remember that the vulnerability of the victims is paramount. The nature of the crime is hidden. It can be very difficult to root out, not just for companies who have to report under the various modern slavery acts that we'll talk about in a second, but also for law enforcement agencies who are tasked with bringing prosecutions against traffickers. the crime itself is by its very nature hidden, and it exists in the margins of society through deception and coercion and criminals maintaining a low profile. So it's important to accept at the outset that it is difficult to root out, which is why we've seen the legislative approaches taken by different countries to date, aiming at sort of transparency and companies making their best efforts to try to root out slavery in their business and supply chains where they can. So in reference to the perpetrators, and modern slavery is actually a business, and it takes the form of different business models depending on the perpetrators. And businesses should be on the lookout for different ways in which the modern slavery can take place in their business and supply chains, because depending on what business model the perpetrators are adhering to, there will be different actions expected of the business to try to root that out. So on the one hand, you have state-controlled or sanctioned modern slavery. The example of that is prison labor in the US, which many people are surprised to know still happens. You also have the business model of the exploitative employer, and this is the kind of direct where the employer themselves actually has the intent to deploy practices including modern slavery. Either they know they're doing it or they're complicit in doing it because they are using practices that indicate they should know. So you're not paying your labor recruiters enough in order to cover their margins, or you're knowingly employing undocumented workers, for example. Another common business model we see with modern slavery is where you have a rogue manager or supervisor, where this person often has the same nationality as a group of victims, but they're able to conceal their actions through the use of the same native language. And then probably the biggest risk within the labor supply chain in the UK, at least, which is where my practice is focused, is with recruitment intermediaries. So where you have third-party labor providers who are feeding workers into a business, and the level of scrutiny that they may apply in their systems can vary from the outright criminal to perhaps unacceptably naive about how they're recruiting workers. So that's kind of the background of modern slavery generally. I'm happy to take any questions that might come up as we move forward, but I'm conscious of not wanting to overrun my time too much. So Chris, you asked also about what are the kind of latest trends in terms of modern slavery risk management, and how are they reflected in legislation around the world. So really quick overview, because obviously we could spend a long time talking about this. I think we see the origin of transparency reporting legislation, meaning companies being expected to publish some kind of a statement containing some kind of information about what they're doing to manage modern slavery risk in their business and supply chain. And depending on when this act was passed, which jurisdiction, it's going to have different thresholds for reporting entities, different contents for what the reports should contain, and other kinds of different form requirements, different levels of penalties for non-compliance, et cetera. But I would point to the California Transparency in Supply Chains Act as really the origin story behind modern slavery transparency reporting legislation. And that was passed back in 2010. Following on 5 years later, but really kind of in fairly quick succession in the grand scheme of things, was the UK Modern Slavery Act, which is probably, I would say, the one that most people, at least certainly in people that I work with in my practice, would be most familiar with. The UK Modern Slavery Act has long been, I would hesitate to say the gold standard, but it has set a fairly decent benchmark for expectations of what companies need to be thinking about in terms of reporting on modern slavery and what they're doing. It's been criticized for not having mandatory content requirements and for not having any financial penalties attached to it. And we expect some recommendations to be included so that amendments are likely to be forthcoming, but obviously COVID has maybe put a pause on that action. Following on from the UK, we have the Australia Modern Slavery Act, which is sort of sitting in competition with the New South Wales Modern Slavery Act, which is the state level law in Australia. Again, there's going to be some work to do in terms of harmonizing those two pieces of law, but the Australian Act built on the UK Act in that it set out mandatory content requirements as in terms of what a company actually needs to report on. And the government also released some quite useful guidance so that companies who are coming to this for the first time, who maybe would not have been subject to the UK Modern Slavery Act requirements, but are subject to the Australian ones, will find lots of resource there in terms of how to get started. So that's quite good. Next in line, I would say, is going to be Canada. Again, I think COVID has put a little bit of a pause on this development, but it looks like Canada is posed to enact their own Modern Slavery Act. And again, we see this progression from the early movements in California and in the UK to now Canada, where we will have financial penalties of up to 250,000 Canadian dollars. There are, again, very clear content requirements in terms of what exactly a company needs to report on. And it will also capture a wider group of companies. So either a company will have to report if they have 20 million Canadian dollars in assets or 40 million Canadian dollars in revenue, or an average of 250 employees. So you can see how already the net is getting a little bit wider. There's also potentially something coming out of Hong Kong. We, again, don't really know what the update is there, but I would say that gives the kind of overview for what transparency reporting legislation is out there on modern slavery right now. Adam's going to talk to us in more detail about other kinds of legislative developments, especially those involving due diligence. But it's important probably to note here that the Netherlands is one country where we see the due diligence approach being taken, but with respect to modern slavery, specifically child labor. So it's not quite the same as these transparency reporting legislations where it's clear what a company needs to report on and they need to publish it on their website, but this is more company needs to do due diligence to determine whether there's reasonable suspicion that goods or services have been supplied using child labor. So that's something different. There's lots of other approaches as well. The US Federal Acquisition Regulation final rule is one example. The Brazilian dirty list is another example. But I'm conscious that I'm probably running over my time. So it might be best for me to pause there and then we can come back as needed.
Yeah, no, thank you. And I mean, that kind of paints a patchwork of regulation out there. And one thing I'm just wondering is how, who's subject to which law where, and how does that really play out for companies with operations all around the world? But Jonathan and Adam, have you got thoughts on this?
Go ahead, Adam.
Thank you, Jonathan. One of the questions I was going to put back to Mary on this is in my experience, one of the big things about the slavery legislation is that it's really changed the nature of discussions within companies and kind of escalated this up to management committee and board level as a kind of as something that essentially can't be avoided or simply just delegated down to a committee, particularly where the UK legislation has an obligation to sign these statements at a high level. I wondered, Mary, is that something that you've seen, and has that changed the nature of the discussion that you end up having with your corporate clients?
Yeah, it's a good question. I mean, the unfortunate reality is that even though we're 5 years on from the Modern Slavery Act in the UK, being given royal assent, compliance is still fairly poor, really. The requirements are actually very low compared to some of the other laws that we've seen, especially the Australian one as an example. But so as Adam mentioned, you need to have a director sign and approve the statement along with the board. It needs to be published on the website. But in terms of what you actually say in your statement, under the law as it's currently written, you are legally allowed to write a statement saying we haven't done anything. And that would, in theory, pass muster with what is actually expected. Now, obviously, I would never advise my clients to take that approach, even though it might be legally compliant, because it doesn't actually serve the purpose of giving consumers the amount of information that they need to choose, you know, in terms of which businesses they may want to treat with. So, you know, I say that compliance is not very good. There are several different civil society organizations that actually go through all the statements that are published as they're published and sort of give them a ranking as to, you know, whether or not they meet the basic requirements. And I think it's something like 30% of the statements that have been published actually are deemed to have met the quite limited reporting requirements under the UK law. So being totally frank, we still have a lot of work to do, I think. But, you know, Adam, you do make a good point that obviously the direction of travel is such that companies are not really able to completely turn a blind eye to this anymore. The issues are landing on the desks of the people who need to know about them and who need to make decisions as to how a company is going to manage those risks. So, you know, we do see incremental progress being made.
But I think if I could just come in, you know, I did see, Mary, and tell me if I'm wrong, both of you guys, because I know you're much closer to the UK than I am. They are talking about strengthening the requirements for modern slavery act reporting, and because I think they found about 25% of companies who should be filing reports aren't, and make the 6 recommended issues mandatory, clarify that it does really require board level reporting, include potential penalties, et cetera. I assume that's in response to some of the concerns that you're identifying there.
Yeah, exactly. And I think it's probably worth pointing out that because the UK was relatively pioneering in getting this off the ground, the approach, as I understand it, that the government at that time was taking was very much, let's not make this too onerous for companies to comply. Let's just set a really low baseline, make it easy, get over the baseline, and then as we see how this is progressing, then we can make some recommendations as to how we can strengthen the teeth in the legislation, which is exactly, as Jonathan says, what's planned for the development. So I think harmonization is a theme generally where we could really see the purpose of all of these different laws start to kind of really come together, because for example, one of the proposed amendments to the UK law will be to have a synchronized reporting deadline so that all companies just have to report by the 30th of September, and that's that. To me, that makes a lot of sense. It's a really easy thing. It doesn't necessarily make anything more onerous. Similarly, you know, recommending that these 5 or 6 content suggestions become mandatory is, again, really simple, because if you're doing the job correctly, these are the kinds of issues you're going to be reporting on anyway. You know, it's not rocket science. So I think it's a matter of watch this space, really. We're going to see harmonization as we move forward. Because, you know, I think back to your question, Chris, because the standards are different for each one of the different laws, a large multinational, you know, could reasonably say, this is confusing. Which laws do I need to report under? How do I harmonize what I'm reporting for Australia versus what I'm reporting for the UK versus what I might have to report in Canada?
We've lost Mary.
Produce this kind of information, then we need to try to make their job as easy as possible, really, and not sort of, you know, create too many complex requirements.
So, I mean, modern slavery is, of course, one important issue. There are many more in the human rights world. If we can turn to you now, Adam, ICoCA is a mechanism to strengthen human rights due diligence in the private security supply chain. So can you tell us how this fits in the broader landscape of human rights due diligence? There are a number of regulatory developments that are going on, including here in Switzerland, right this week, next week, I think. So can you tell us a little bit more about this?
With pleasure, and let me also say thank you very much, Chris, for having me on, and Mary for that kind of really interesting kind of start to the discussion. Certainly, I think with the ICoCA Code of Conduct and the membership, I can say that you are kind of ahead of the curve in having been looking at these issues already, and trying to grapple with what they mean at a kind of individual member, kind of practically, because that is exactly the objective that the policymakers and legislators are now trying to make mandatory. And I think in terms of continuing the trend that Mary started to talk about, really we're seeing this expansion now from a focus on single issues and on disclosure, and I think that's largely what Mary's been talking about, to an expansion across the kind of full gamut, the full spectrum of human rights, and looking at how companies should put in place essentially adequate processes and procedures to identify and take appropriate action in respect of any human rights impacts, especially negative ones. And the key here, when thinking about human rights due diligence, is that you're looking not in a kind of traditional corporate due diligence way about what is the corporate aim and how do you get there. You know, what licenses do you need? You know, what people do you need to have in a particular post, that kind of thing. But it's looking at what impacts fall on rights holders, which could be in or outside of the company, and could be anywhere. It could be in your supply chain, could be people that you engage for services, could be in local communities, all manner of different people. So the trend really is to make that process something that companies have to take on for themselves. But it gives rise to all manner of kind of, from my point of view, fascinating kind of legal and strategic commercial dilemmas, which companies are now trying to get their head around, and trying to help policymakers to put in place a good law. And I thought I would take you through some of those laws to see what's led up to where we are now. And I think that the big topical issue, apart from the RBI in Switzerland, which I think is going to a referendum at the end of this month, is the legislative initiative being led within the EU. Mary mentioned how COVID has maybe arrested some of the progress in some of the legislation elsewhere. In Canada, I think you mentioned, whereas the EU is kind of the opposite. It's been a catalyst for a process that's already been happening, which now seems to be moving relatively quickly. And I say that because the EU is not famed for its speed in legislating. But in terms of one of the reasons that the EU is acting is because it feels a need to harmonise in this area, precisely, I think, Chris, to your point earlier, to avoid the patchwork of different requirements and obligations popping up all over the place. And there are already within the EU national laws and obligations that companies are already having to grapple with. So if the UK Modern Slavery Act is the kind of poster child for the slavery legislation, then France, I think, takes that honour in respect of human rights due diligence, and its duty of vigilance law that was introduced in 2017 is significantly further ahead than most other pieces of national legislation. Mary's already mentioned the Dutch child labour law, which has been enacted, although not yet brought into force, but that also brings in elements of mandatory due diligence processes, which companies will need to get their head around. We talked about Switzerland and whether we go one way or the other in terms of whether there is corporate liability or there isn't. There will be some change arising out of the referendum result on the 29th of this month. So that will be a topical one to watch. And then there is a kind of bevy of other either proposed laws or civil society initiatives, some backed by businesses in Belgium, Denmark, Finland, Germany, Italy, Luxembourg, Norway, Sweden, and a few in the UK. So this is an area, even just looking at the EU, where there's a lot of moving pieces, and businesses are starting to think, do we try and comply and localize our compliance to each different market, or do we try and find the most onerous and apply that across the business so that we can say with some certainty that we kind of tick all the boxes, not that compliance should be done on a tick box kind of way. But that does take us up to the EU, and where are we? Well, the European Commission has said that it will be introducing a legislative initiative, which it intends to lead on to a fully blown EU directive. And it was due to be introduced Q1 of next year. They've pushed that back a little bit to Q2. And I think that's in part because their public consultation has only just been launched, whereas they were hoping to have wrapped that up already. So if there's interest in the members, we could talk about what that consultation means during the Q&A, but it's open until the 8th of February. And until that point, the Commission's being fairly guarded in terms of exactly what it has in mind. It probably has a very good idea what it wants to do, but it wants to be able to say that it's reached those kind of decisions or made that proposal, having listened very dutifully to all manner of different stakeholders. And there are a lot of different submissions being put into that process. So come kind of spring next year, we will see a change from a kind of concept discussion to a much more concrete conversation around specific issues, which will be interesting for your members. I think in terms of the key issues from a legal and corporate point of view, we will be keeping an eye, and I think members should be keeping an eye on things like, what are the precise obligations. The UN guiding principles taught, for example, are based on the idea of proportionality and taking a risk-based approach. That has been baked into legislation like we've seen in France and in the Netherlands. But some kind of stakeholders, for example, in civil society organizations, have pushed for a much higher standard, for example, where liability rests for failure to prevent human rights abuse, rather than an obligation to have an adequate process that kind of feels like it should do enough, but recognizes that you can't avoid every negative impact, even if you have the best intentions and try pretty hard. We'll be looking to see what the scope of this legislation should be in terms of what rights it covers, and generally speaking, there seems to be agreement that it should cover the full spectrum of rights that are set out in some of the core international instruments. What violations are covered, I've touched on that. Should it cover all businesses, or should there be thresholds like Mary's talked about in the UK Modern Slavery Act? I think there's a clear message from the Commission that this is meant to be all companies and cross-sector, and that's very much designed, I think, to kind of achieve this level playing field, which lots of people are keen to see. And what kind of business activities will be covered within the scope? Are you looking at up the chain, down the chain, all your various tiers of supply chain? And again, there seems to be a big push to make this exceptionally broad in terms of scope, but perhaps with some kind of reasonableness test kind of baked in. And we can get on to talking about what the kind of monitoring and reporting requirements will be, and how they will be coherent and consistent with existing requirements that Mary's talked about, existing EU requirements, for example, under the non-financial reporting directive, and the like, and whether, for example, there will be some recognition that people who already report to industry groups such as ICoCA, whether there's some kind of presumption that they're already doing enough, or at least some kind of credit. And I would suggest that would be very well received within the industry community, and would be due recognition of good work that's already been done. Been kind of casting my mind about how this will affect private security companies in particular. And I think one of the interesting aspects is that private security has this kind of dual role. It's protective of human rights, but also need to protect the human rights of those people who are providing the service, but also they're at the kind of cutting edge, not only for their own company, but for their own internal clients, of the external relations with all kinds of different stakeholders. So I think there are, and we can get into this in the discussion perhaps, there are various different ways in which the private security individuals and companies will find themselves, or should find themselves, having a role in terms of identifying issues, communicating them, helping to assess them, helping to prioritize them, and no doubt having a big role in the steps that are taken both to prevent future harms and maybe even to establish some kind of effective remedy. I've got a few other thoughts, but maybe I should wait to see whether they come up in the discussion. But it's certainly going to be an interesting time, Chris, as you say. And I think there's a potential for this EU directive in particular to be pretty transformative, not unlike the kind of GDPR, which means that everyone now has to tick 1 million different consent boxes before you can sign up to anything. But I think probably in a broader and a more impactful way, both within the EU, but also with effect outside it as well.
I'm glad that you brought up the potential synergy between soft law kind of mechanisms like ICoCA and this hard law that's kind of in the pipeline, and just wondering, what others might think about this. I mean, has ICoCA got a role in the future of due diligence, or is hard law seen as being, the gold standard, and we don't need these things if you have law?
Well, let me kick off by saying that I think there's a general sense that whilst a lot of people are talking about human rights due diligence, people who have been putting their mind to it know that this isn't a silver bullet. This isn't something that's going to make everything go away and fine and dandy. And whilst there is an element of overlap with ICoCA, Code of Conduct, with the UNGPs, with the VPs, the way I would look at it is mandatory due diligence, human rights, environmental, whether it covers governance or not, really is one of the tools and focuses only on a part of those broader expectations that are established in these kind of soft law instruments. So it will take part of that and make it much more important internally from a kind of liability and a compliance point of view. But there's much more that will need to be done to really be operating as a good corporate citizen, to be playing, the role of other members in ICoCA, government, NGO, academic even, which aren't touched on or won't be touched on by human rights due diligence laws at all, and probably shouldn't be. So things like, how do you exercise your leverage? To what extent do you campaign? To what extent do you try to assist governments in complex, challenging environments to improve their own capacity? That's maybe not an area where companies will have, this new crystallized hard law obligation under these new laws, but it's certainly not an area that I think companies should be quick to forget about.
Jonathan, a lot of this talk is kind of a bit European focused. So what's the view over the pond from the States on
Yeah. No, I think it's a great question. I mean, I would say, just as a side note, the U.S. doesn't have, we have California, as Mary mentioned, in terms of something akin to a modern Slavery Act law. We have a little bit of mandatory diligence here and there. And so you could look at it in terms of federal acquisition regulations. You could look at it in terms of conflict minerals here and there, but nothing nearly as comprehensive and transformative as what Adam is talking about, either on a European and EU member state basis or the legislative directive. With the Biden administration, I would imagine there will be at least talk of a Modern Slavery Act. And if you think about this as sort of a progression, a Modern Slavery Act being a first step that only requires you to kind of say what you're doing, which would be more consistent with what we've seen, for instance, in the conflict mineral legislation. And what Adam's talking about, mandatory diligence being the next step, I think we would certainly see a fair amount of support for a Modern Slavery Act, particularly Canada is talking about it, as Mary said, our neighbor just to the north. I think, though, at the end of within 4 years, I think there's going to be talk about the possibility of more expansive mandatory diligence as well. And I would not be surprised that if with this incoming administration, that does become a topic of discussion.
I think one of the reasons that I completely agree with you, Jonathan, which I find myself doing all too often, is that the EU talks about what it calls the Brussels effect, and that's the idea of it being such an important market that rules about what happens if you're operating in or selling into or providing services in the EU from outside mean that some of the big US companies will, and some of the medium-sized companies in the US will likely be directly affected by the EU directive, and so I talked earlier about a level playing field, and you almost have this surprising consequence where actually some of the bigger companies are calling for it because they themselves find themselves having to meet these obligations, but they see their smaller competitors blissfully, perhaps on one view, free of it, and so they say, well, let's have this at home, and they'll talk about driving up standards, they'll talk about human rights protections, which is completely proper and right, but I suspect that one of the big reasons under the surface will be to have kind of a fairer competition, given the standards they will be expected to meet.
Just to jump in there really quickly, that's a really good point, Adam. And actually, the Australia Modern Slavery Act was passed after extensive consultation with Australian businesses, who basically put their hands up and said, listen, we're going to have to cope with this to the extent that we have to report under under the UK Modern Slavery Act, for example, but also, maybe some with the valiant thoughts in their hearts about how good it is for the world that they be asked to report transparently on these things, but also, as you say, to make sure there is a level playing field and to make sure that the standards are clear. I think I've heard a lot of complaints from various different business entities that without clear guidance on what exactly they are meant to do, report on, implement, ask their supply chain, put into their audits and their questionnaires and all this, without clear guidance, they find it difficult. And so it's a really good concrete example of that exact thing taking place.
So Adam, Mary as well, I know being in Europe, I mean, for private security companies, how are they going to be impacted by the mandatory diligence law, right? You're going to have their customers who are doing business in the EU, who are going to have to then talk about the nature of their business relationships, including their relationships with private security companies and the risks that may come out of that. Is that how that is really going to impact the ICoCA members, for instance?
Yeah, I think taking that first, I think there will be multiple impacts, and one will be where you are providing a service to another company which is caught by these new obligations. And those companies will only be able to meet their own new obligations and potentially avoid liability if they can say that they are exercising proper oversight over the security that's provided through, for example, an ICoCA member. So I think the first angle is that you will find yourself having to answer all manner of new questionnaires, sign off on new standards, deal with potentially new contractual terms from your corporate partners and your external customers and clients. So that's one. I think another one is those companies that will be directly caught, and those obligations then apply both to your operations, so thinking active programs, but also to your own supply and value chains. So it's quite easy, I think, conceptually for a private security company or service provider to think, okay, if we're putting forces on the ground here, these are potential and likely human rights impacts, and this is what we might do to monitor and mitigate them. But what about who's manufacturing the weapons and the raw materials that have gone into that, or even more logistical things like who's providing your food? It's very easy to imagine that kind of coming out of relative left field on some of these could be a headline. We're only a kind of Instagram picture or Facebook or tweet away from a human rights scandal or alleged scandal, which can be linked pretty quickly to a company, and you may have known nothing about it. But if it's a small mom and pop shop in a local kind of field that you're engaged in, and they've been helping to provide some kind of service like food, for example, but actually their little 7-year-old is making the sandwiches out back, then that can quite quickly become your problem. It does bring us back to what we were saying about what's proportionate, how you prioritize, where your real and most kind of important risks are, and the guiding principles talk about saliency, for example. So I think there's some kind of, hopefully some inbuilt protections there, and I don't think companies will be expected to have this 100% perfect knowledge and vigilance. But equally, I think companies will need to look at where those risks might pop up, and they might not be in the most obvious places. So that kind of brings you back to starting off trying to rid yourself of assumptions of where they might be, so that you can kind of come at it afresh and look at where these human rights impacts might be. But it could be indirect, it could be more direct, and it could be from your indirect procurement, or it could be from soldiers you're putting in harm's way.
And much of the kind of conversation that we have is about private security as a piece of the supply chain. But of course, these companies need to look at their own supply chains, like you're saying. So it's interesting. Jonathan, I want to turn to you, because all these laws are only really effective if they are firstly accessible, and if there are consequences for those that break them. So, how is the human rights kind of litigation landscape looking right now? Are cases being pursued? And are the penalties and sanctions severe enough? We've heard of one figure Mary brought up with the proposed Canadian legislation. Are these kinds of penalties severe enough to deter violations from occurring?
Yeah, let me start with that point and then talk about the litigation. So I do think one of the lessons that we've learned is that voluntary quote unquote reporting, or reporting that doesn't come with some kind of penalty, is not going to be nearly as effective. I think that is one of the lessons. And so I think the Canadian legislation is very much picking up on that, and some of the changes we talked about regarding the UK Modern Slavery Act also is picking up on that as well. And the EU directive that Adam was talking about contemplates that very much, and includes both civil and potentially criminal liability provisions. But on the litigation front, where we started in the business and human rights space 20 years ago was really around soft law norms and litigation. And we continue to see a lot of both. And litigation particularly continues to move very actively. Cases are being filed in the US, in Canada, the UK, and elsewhere. Often, these do have security-related claims, either public or private security claims that are components of them. We had a big decision this year coming out of Canada, allowing cases to go forward based on international norms. Big case in the UK last year, focusing on parent liability. So these cases are continuing to be filed. In the US, there's a big nucleus, a big bunch of cases right now that's focused on forced labor, labor trafficking, which does have a security component that's associated with it. So that's very active. There are a lot of cases actually in the US right now that aren't as talked about as much, about how goods are described. They're under deceptive trade practices. And are you selling goods that are produced in a socially responsible way? And that also has a potential security component that can come in as well. I do think that those are going to expand under a Biden administration. I think we are going to see more cases, and we are going to see more cases supported by the administration as far as those go. In addition, outside of the pure human rights space, we are seeing more cases that have an ESG or human rights component that involve board liability and director liability. So consistent with what we talked about before in terms of responsibilities being put at the board level, the litigation trend is going in the same direction. It is putting cases against directors very much front and center, and those cases are actually getting through. They're getting by your initial dismissal phase, which is kind of the goal of a lot of these plaintiffs' lawyers in terms of their approaches. Beyond just the litigation front, though, one of the big trends we've seen in the last couple of years, and to the credit, frankly, of the Trump administration, is the integration of human rights into other international regulatory schemes, not just the US, but elsewhere. And by that, I mean, we now have sanctions that are based on human rights abuses, economic sanctions against individuals, against entities based on human rights abuses, including out of places where private security do have a role and are involved. We have trade and human rights ultimately being linked. And so stopping goods at the border where they may be created with forced labor. And that is something that the US is now putting in its trade agreements and requiring of some of its trading partners, Mexico, Canada being two immediate ones. We're seeing export controls. The sale of goods have different human rights components to them, and the US government reacting by identifying certain companies that shouldn't be sold to because of human rights related issues, where there needs to be specific approval. So you have export controls as well. Money laundering also is increasingly being looked at with a human rights lens, particularly as it reflects trafficking. So in addition to the human rights issues as human rights issues in and of themselves, and there are statutes, part of that litigation, like the Trafficking Victim Protection Reauthorization Act, TVPRA, that allows human rights cases. We're also seeing human rights being integrated into these other approaches that do have penalties and sanctions and prohibitions and limitations that ultimately are associated with them. So they're really the punchline that I will make and frequently make is, number one, if you are associated with a human rights violation, it's going to be pursued somewhere, somehow, in some forum, and there will be ramifications. Number one. Number two, governments increasingly are making this a priority as a policy matter and figuring out how to implement those policies in different ways that have penalties and sanctions associated with them. And number three, companies are increasingly being expected and demanded to respond with programmatic approaches, taking steps ahead of time to try to avoid human rights abuses through governance and policies and procedures and due diligence and training and investigations, all of those kinds of things that go into corporate programs, and often you see, quite frankly, in good security related programs. But I think that is something that increasingly companies are now being expected to put into place to try to avoid problems.
So, I mean, the sanctions is really fascinating. I mean, is there any kind of indication as to, which is the more effective approach, a sanctions-based kind of approach or penalties for breaking law?
Well, I think they're both. I think they serve different purposes. I think where you can't actively enforce penalties, sanctions are really useful. Sanctions have a huge, broad impact on the ability of somebody to do business and people to do business with that sanctioned entity. They have a huge impact. But I think there is no question that if you can exercise jurisdiction over somebody, whether it's through a criminal case or a civil lawsuit, that is going to have a more immediate effect. So I think we generally look first at the litigation or criminal penalty approach. And where that really may not work for various reasons, you think about sanctions a little bit more general.
So Adam, Mary, are you seeing more kind of cases being brought to you on the human rights front?
Absolutely, and I think Jonathan mentioned the Vedanta case that was in the Supreme Court here in England, in the UK last year, and Omnia was involved in that. We were representing interveners, so we were lucky enough to to be there in court and hear the arguments, and that was the case that involved. It's still ongoing now because basically jurisdiction was exercised or seized by the court, so then they sent it all the way back to the bottom to the first instance court to start again on the merits. But that was a case that was on its face around environmental damage with the claimed pollution of a waterway in Zambia. But the inability to bring a case effectively in Zambia, largely because there was no funding available to the claimant lawyers, meant that the UK courts found themselves saying, and it's actually written into the judgment, we don't want to be colonialist about this, but there's just nowhere else that these claimants can bring their case. And I think that goes to Jonathan's point really well in terms of it will pop up somewhere. And it also struck me, and it comes back to what Mary was saying earlier about the possibility to be compliant with the Modern Slavery Act in the UK and say, we've taken no steps to combat slavery in the last year. There's almost a feeling within some quarters of the corporate world that there's perhaps this kind of unintended disincentive to disclose and to put in place programs and to have effective oversight, because cases like Vedanta, you'll get courts saying, well, that is exactly the evidence we're looking for, that actually there is some duty on the part of so some legal obligation on the part of the parent company, which has been breached, and therefore there should be a remedy. So you get some perhaps more kind of conservative in-house general counsel or even external advisors saying, well, look, this just shows that you shouldn't be putting those oversight mechanisms in place, or you shouldn't be talking about it because it just is a rod for your own back. Now that, is persuasive in some ways, but I think actually it ignores the other myriad of kind of pressures and trends towards actually getting your head around this in a more effective way. So I would say it doesn't mean don't do it. It just means do it better, and that's obviously without passing judgment on that particular case. But I think there are more cases. We've done work in the human rights space where we've tried to, or we've been involved in approaching governments to sanction people because we know that will have a real impact on corporate and state actors. It's a very interconnected world. Money is all over the place. There'll be people with their assets tied up in dollar accounts in the US or property in London, and being told that that's frozen because you have been implicated in some way in some human rights violation is effective because it gets people in their wallets.
Yeah, I do think Adam makes a good point in terms of there's a little bit of a policy disconnect. There's a pressure on companies to disclose their responsible business conduct approaches, including around human rights, a real pressure. There's benchmarking, there's pressure by investors, by shareholders, by employees, by business partners, big pressure. But when companies do, they are being used, these non-financial disclosures, for purposes of either liability. The Nevson case in Canada, the one I mentioned before, the big Canadian case, was also based on non-financial disclosures, how a company was complying, it said, with IFC standards. You have it for parent liability, you have it for other reasons as well. And I think, from a policy standpoint, we do want people to disclose and be transparent. We don't want that to be used against them. But I do think the middle ground, and if you were to ask NGOs and plaintiffs' lawyers and others, is they would say, whatever you say has to be right. It has to be accurate. I think you get a lot of credit frankly, for being, for disclosing. And I think people will, especially those who tend to bring cases, they will give you a little bit of benefit of the doubt if you are trying to be transparent in your disclosures. But I do really think you need to take care in what you say and put as much care into any financial and non-financial disclosures as you do financial disclosures, in order to avoid these kinds of problems. But there is a balance. We're all kind of trying to figure out exactly how to work out.
Yeah, just to jump in on that quickly, one potentially positive example, I think, and this is from a few years ago now in the UK, there was modern slavery discovered in a mattress factory, and it was found that there were two main consumer-facing brands in the UK who were purchasing mattresses from this factory and didn't know about it. And they had sent some ethical auditors to go and check it out, but nothing was uncovered. And then all of a sudden it was all across the front pages of the newspaper. And they actually did, the case was prosecuted, and one of the directors of one of those consumer-facing big brands was brought in for testimony. And he was able to say, these are the due diligence processes that we have in place. We did everything we reasonably could be expected in order to check for this, and we didn't find it. And in the end, then that information and evidence was considered in not joining those companies to the case. So actually, I mean, that's only one example, but it does show that, there are cases in which that can work in your favor, really.
Chris, I saw a question on the Q&A. I wondered if I might just jump on that one, because it relates to what Mary was just saying.
Turn to the Q&A, absolutely. So yeah, go ahead.
Sorry, I'm not trying to preempt your good job, but I saw a question about the Bribery Act from, sorry, I forgot the name, James Sinclair, I think. And I think it's a very interesting question. So the setup of the Bribery Act is that you have strict liability. So if bribery is found, the starting point is that you are liable for it, you're responsible for it. So that's a reverse burden of proof, and that's the point made in the question. That is being used as a kind of conceptual framework for some of the human rights regulation that people are talking about. So where in the UK, for example, we talk about a failure to prevent, the idea is that if there is a human rights abuse, the presumption would be that the corporate is responsible, unless you can show that you have an adequate process. which is exactly the approach in the Bribery Act. So you have the kind of strict liability, but then you have a get out mechanism by being able to show, just like Mary was saying in her example for the mattress company, that you've done everything you could. And that is certainly one approach that could be taken by some of these up and coming human rights due diligence mechanisms. I suspect that the EU will prefer to put its obligations more in terms of what the process should be, rather than a liability for the outcome. But that is very much a live issue.
And I just want to check, because we are coming up to past soon. Are we able to run over by a few minutes for our panelists? Does anybody have a hard commitment?
Fine by me.
I am going to need to jump off, unfortunately.
Okay. So James Sinclair, who, by the way, we did a great podcast and also does great work on modern slavery, fascinating kind of work he's doing. I recommend listening to it. But he also touches on a question we were talking before we went live. So to what extent will the investment community drive improvements to corporate accountability? We've seen the Norwegian Sovereign Wealth Fund divest from G4S as a result of alleged labor exploitation issues. This seems to be a growing trend. Do we have thoughts on that?
Yeah, I think it is a growing trend. I mean, I think there's been a lot of focus on the financial sector. And in fact, there's a new OECD due diligence guidance focusing on human rights in the financial sector. And I think that, you know, this has been and in part, it's based on the leverage and influence that financial institutions have. And that can be private equity, it can be banks, it could be the IFIs, the multilateral lending institutions, export credit agencies, and others. But the fact that the pressure is basically on those who have the power of the purse to either put standards in place or divest as a way of sending a message to the larger business community about responsible business conduct generally and human rights more specifically. I think there's no question that's going to continue, in part because it's worked. And whenever you see in this space something that ends up being effective and getting results, you're going to see it more and more and expanded. So I do think, you know, that is an increasing area that isn't about to stop.
And I think also that I completely agree. And I think that's coming from financial institutions as investors, but also groups who are investing in companies as shareholders and using AGMs and resolutions and that kind of shareholder platform to pressure and to call for changes in policies, changes in procedures. And that's already having, you know, real life changes at the kind of board level.
And a very last question, we'll try and squeeze it in. Given that there's often a limit to the level of compliance that education and regulation can achieve, are there any innovative or novel approaches being used to try and encourage organizations to be more proactive in addressing human rights risks, and in particular, the targeting of modern slavery in their direct and outsourced supply chains? This may be out of the remit of our lawyers, but good question.
No, I don't think it should be. I think lawyers should be very much in the business of trying to give ideas, but beyond the black letter. I think it comes partly back to what John was saying earlier about the need to give due recognition for companies who are making a good stab at this. And you know, you've seen Unilever, for example, in their industry saying, you know, our aim is to respect human rights to the utmost, and in so doing, to help spur our growth, our commercial growth. And you know, Paul Palmer's just moved on, but I think broadly speaking, the verdict on his stewardship of the company has been hugely positive, and he continues to advise other companies in this area and to kind of call for that. So I think due recognition of what's working well is one, and I think we'll start to see companies also wanting to mirror the values of their own customers, particularly where those customers are consumers, and starting to be a little bit more vocal on some of the big political issues of the day, where they are aligned with the existing values and operations of the business. So I think finding those matters that are close to the kind of beating heart of the company and having the courage to speak out on some of those is an area that business executives have already identified as being good business.
I think I just really quickly also push back a little bit, if I may, on the premise behind that question, because in my experience, I've actually found that education in the form of training for employees in these businesses actually has a massive impact. You know, a lot of the times I'll start a training session of 100 people working in, you know, a large supermarket or members of their supply chain in the UK, and find that, you know, no one knows what modern slavery is. It's just not a concept that they come across during their dinner table conversations. And so when you're able to kind of give examples of actually the horrific conditions in which people are being treated, and just how close that actually can be to their day-to-day work, you see the light bulbs going off, and then people go away and they say, oh, I want follow-up training, or I want to make sure members of my team can go on this training, and I want to make sure that we can be monitoring our progress, you know, year on year, and I want to do something about this. So yes, I agree that there's a limit to how much that can encourage compliance at the top level, for perhaps, and regulation the same, but I do see actual real impacts of that level of training and education.
And that is one area that ICoCA is increasingly looking at getting involved in as well. So I hope that there is appetite for it. But look, I want to be respectful of the time. Thank you so much to our panelists. Thanks to everybody for being online. This is clearly, the good news, this is clearly an area where much activity is going on. And we look forward to more conversations and keeping an eye on how the legislation progresses. But for today, thanks to everybody.
Thanks, everyone.
Thanks.